thank you. And I feel much better about speaking in English after what Hartosh said about Hindi imperialism. So I'll speak in English, and I'll assume that it's a statement against Hindi imperialism. Some of the larger points about the UAPA and the UAPA's draconian nature have been made. And I want to bring the focus back to Umar's case and to the legal proceedings so far, because I think that even in the context of the UAPA's provisions that make getting bail very difficult and so lead to long periods of imprisonment, even in that framework, the proceedings in Umar's case are quite extraordinary in a bad way. It's not your common UAPA proceeding, and I'll explain what I mean by that. So, just to again recap, there is Section 43, Clause D, Subclause 5 of the UAPA that says that as long as there is a prima facie case, which means if you look at the police version and that makes out a case on the face of it, then the judge is barred from granting bail. That in effect is what the provision says. And there are judgments that say that the kind of scrutiny that the court can exercise is of a light touch variety. So they can't go too deep into the police's case, but they can of course look at it and see if it makes sense on its own terms. So there is still scope for judicial intervention, and that's why you have people getting bail in UAPA cases. It's not unheard of, it happens. It happens because the police still has to do some work in these cases. So they have to show that there was an offense which meets the threshold under the UAPA, terrorism, effectively. So there was something that meets the legal definition of terrorism. And they have to show that there is something that the accused person did, said, or was involved in that can make you infer their involvement in that act. So something specific. So that, and if that is not there, then the court can give bail, and when the court gives bail, you will see that it's one of two reasons. Either that the offense that comes out from the police's version does not actually meet that high threshold of terrorism, it's something less. Or that on the police's version, you can't link the accused person with that offense. So one of these two things doesn't happen, then bail is given. Now, if you cast your mind back to 2020, so you have these protests against the CAA and the NRC taking place across the country and of course in Delhi, in the course of which speeches are given that are of a peaceful character, that exhort people to protest against the CAA and to use constitutional methods to get it overturned or taken back. So you have that, and then you have the outbreak of violence in various parts of Delhi. And the police now has to create a version where they link the first to the second. So that's their job in these charge sheets. And they obviously want to fix Umar as the mastermind behind this. There are three problems that the police has when they're doing this. The first is, as has already been said, the actual things that Umar says are not only non-violent but impeccably constitutional. You can't possibly interpret them in any other way, although as we will see, the one court does do that, and we will come to that. That's problem number one that the police has. Problem number two is that there is no evidence that Umar was involved in anything other than giving speeches. So normally in these UAPA cases, you will have some funding, some funding trail. In the Bhima Koregaon cases, they try to make out some funding relationship between the accused and the CPI Maoists. They try and say, okay, there were weapons found in your possession, or certain kinds of reading material that is, illegal. In Umar's case, there is nothing. There is just the speech. There's nothing other than that they can find. That's problem number two. And problem 3 is that he's not in Delhi when the actual violence happens. Right? So here you have a person who has made a couple of speeches that are completely non-violent, who is not here when the violence breaks out, and there is no record even on the police's version of anything else. So how do you then make out a case, or how do you make out this prima facie case? The way they go about doing this is that in these UAPA cases, you have what are called protected witnesses. So these are people who were involved in the events that led up to the violence, and the police hides their actual names by saying that if we reveal their names, then the actual perpetrators will target them. So their names, and you will see in the judgments, are like Romeo, Juliet, Penny. It's all kinds of crazy stuff. And the police takes their statements. And of course, now what follows is that the accused, not knowing who these people are, has no way to say, whether this person was even there when claiming what they're claiming, or anything of that kind. So that already puts the accused at a disadvantage when it comes to the trial, to bail, to everything else. In this case, even then, the police still can't find anything substantial against Umar, even on prima facie case. So what they then do is, they say that protected witness Romeo, for example, was told by somebody else that Umar was saying that he would do X or Y. That's what actually comes across as the police's evidence. Now the interesting thing is here, and this is one of the really extraordinary parts about this case, is that when the trial will eventually happen, right, and this statement comes that Romeo was told by X that Umar was saying that he would do X or Y, it actually cannot be used in evidence, because the Evidence Act says that hearsay is not admissible. So if I say that someone told me X or Y, then the police must get that someone, bring him to the court, so that the accused person can confront that witness and point out the inconsistencies or whatever. Without that, the evidence is not at all in play. It can't be used. It's inadmissible. Except that the sessions judge, in this case, relies upon that and says that, look, here is some evidence that Umar was planning to engage in violence. So, evidence that you cannot use in a trial to convict Umar, you are using in the bail hearing to deny him bail. That is the extent to which the absurdity of this case goes. And so, when the sessions judge then writes his judgment denying bail, and I want to read out this paragraph because I think this really drives the point home. So, in one para he says that in terms of the charge sheet, which is the police's version, as discussed above, it was noticed that the name of accused Umar Khalid finds a recurring mention from the beginning of the conspiracy till the riots. And then he starts giving examples. So, illustration 1, he was a member of WhatsApp group of Muslim students of JNU. That's point 1. Point 2, he participated in various meetings on XYZ ABC tapes. That's point number 2. Point number 3, he is also a member of the DPSG group and attended meetings at the Indian Social Institute. That's point number 3. Point 4, he gave reference to Mr. Donald Trump, President of the USA, in his Amravati speech. Point 4. Point 5, he was also mentioned in the flurry of calls that happened post-riots, as mentioned above. He was instrumental in the creation of JCC. Now, if you look at these 5 points, not one of them actually is specific to any kind of role in violence. Point 1 is he was a member of a WhatsApp group. Point 2 is he went to meetings. Point 3 he was a member of another WhatsApp group and went to another meeting. Point 3 is referred to Donald Trump, and point 5 is that after the riots there were calls in which his name was mentioned. Now, as there's a proverb, you can't hang a dog on this kind of evidence. And this is where, if you look at other UAPA cases, and by no means all, but in many other UAPA cases, this is the point at which the case breaks down. And this is where the court says that, look, even the police's uncontradicted case, because at the bail stage, you can't contradict the case. Even the police's uncontradicted case does not make out the offense, and that's why they are giving this person bail. Whereas here, the court actually fills in the gaps for the police and says, look, there are all these gaps in the police's version. We, the court, will now fill them in and say, look, this demonstrates that he was actually, all the silences and all the things unsaid demonstrate the conspiracy to engage in violence. So, and this is the next paragraph, and this is the core of the sessions judge's case. Lawyer senior advocate for the accused has correctly argued that Umar Khalid was part of the WhatsApp group MSJ and DPSD, but he has not written many messages in those groups, and they are not overtly provocative or incriminatory. However, the fact that he was part of such groups created for specific objects and his acts of presence throughout the period beginning from the passing of the CAB bill till the February riots, as mentioned above, has to be read in totality and not piecemeal. He has connectivity with many accused persons. So this is the core of the judge's reasoning, right? That you can't, he didn't say anything, he didn't do anything, but he was present and he was there. And that, in a sense, is enough to drive home the conspiracy charge stage of bail. As I said, this is quite, even under the UAPA, this is next level stuff. Right? This is clearly what a reverse engineered sort of thing, where you decide first that you are not going to give bail, and then you are looking for reasons to justify that. And this becomes even clearer in the High Court judgment, and I'll end with that because the Sessions Court is sort of the detailed one. The High Court more or less reaffirms that. The High Court judgment, in a certain way, realizes that this is not enough, and looking like a bit of an idiot if you affirm just on this basis. So they say two more things. First thing they say is that the fact that the riots happened and immediately afterwards Umar is making multiple calls demonstrates that he is involved prima facie in the conspiracy. Now if you ask yourself this question, that the riots happen and you're an activist, a Muslim activist, it would be odd if you were silent. Like, you would obviously be making calls and figuring out what is happening, how do we try and calm things down. Does anyone need help? Do we need to get someone to the hospital? If you were silent after a riot, that would be weirder, right? And not a flurry of calls. So that is one thing they say. And the second is what takes the cake, which I'm sure many of you have read and heard, is that they say that in that speech that he gave, which is the constitutionally impeccable speech, he starts with the phrase Krantikari Istiqbal, right? And he says Krantikari Salam. And there are many different kinds of revolution that are possible, that says. So therefore he should have made clear that the kind of revolution is referring to the bloodless one. Because he didn't say bloodless revolution, therefore that implies that there was something wrong with that speech. Right? And then that becomes the basis of affirming that bail denial. So in a sense, that's what's been happening so far. And it's taken 3 years. And what we have is two judgments, Sessions Court and High Court, that more or less concede that nothing violent was said, nothing violent was done, there was no connection, no individual responsibility that can link him with the riots and the violence. All that you have is a WhatsApp group, he's thereabouts, somewhere, there, and that's enough to keep the person in jail for 3 years. Now, as I said, the UAPA is draconian, and the UAPA is bad, and the UAPA is used to justify jailing people for many years before trial. But even under all that, this is extraordinary. This is something that you don't often find in these kinds of cases, which of course leads to uncomfortable questions about why this is happening and what the implications of this are, and is effectively what's happening is a person being made an example of because of what they say and what they do and the rest of it. So I think that is the window of what's happened, and I do think that bail will come soon. I think it will come soon because the Supreme Court has said that a lengthy period of jail incarceration is in itself a ground to grant bail. And if you look at some of the previous cases, normally when it starts reaching around the 3, 4, 5 year mark, they tend to give bail. The idea being that, okay, spent long enough in jail and now whatever was meant to be, done, it has been done through that process punishment matrix. So I do think that bail will come soon, and to whatever extent that's a good thing, it's obviously a good thing. And of course, as was said, the years lost in jail that can never come back. I think that one thing that we should keep in mind is that there is this, and I'll end with this, there is this concept of political justice in political theory. A scholar called Kursheimer coined that, which basically was that when you use the law and the legal machinery to attain political ends, and weaponize the law and the legal machinery to obtain political ends, that is what he calls political justice, and he dedicates his book to all the victims of political justice, what he calls that. And so I think that we need to, when we are talking about this case and in the quest for accountability as we go along, as the future comes to pass, I think we must remember this case as, even in the landscape of political and legal cruelty that is the UAPA, this stands out as particularly cruel and particularly vindictive. In that sense, one of the starkest victims of political justice is Umar, and that's something we should keep in mind. We shouldn't conflate this case with the UAPA more generally. It is an example of it, but also it's a lot more. And so with that, I'll close, and again in the hope that an expectation that yes, he should be free soon, that should happen at least. Thank you.